Well, good morning, everybody, and welcome today to our conference titled New Normals, the Trump Administration, the Courts, and Administrative Law. My name is Adam White. I'm the director of the C. Boyd & Gray Center for the Study of the Administrative State, and it's my pleasure to welcome you all here today. Now, as our name indicates, our center exists to study and discuss current events in modern public administration and the rule of law. Sometimes we debate timeless questions, and sometimes we debate newly arising ones. We thought that the midway point of a presidential term is a good opportunity to take stock of new issues that have arisen or have intensified in the first 2 years of the administration, to discuss them against the backdrop of the broader history of administrative law, and to think about what recent developments may or may not mean for the future of administrative law. We have a variety of panels throughout the day, as the program indicates, some focused on broad themes, some focused, for example, our later morning panel focuses on the case study of environmental regulation specifically. But we're looking forward to a number of broad conversations and, of course, audience questions. We thought we'd begin the discussion today with the conference today with a discussion of presidential administration. Now, as Justice Elena Kagan observed in her now famous 2010 article on presidential administration, presidents have made, quote, the regulatory activity of the executive branch agencies more and more an extension of the president's own policy and political agenda. Now, this trend, in turn, makes judicial review of agency action become something growing ever closer to judicial review of presidential policy. And furthermore, as President Trump puts his own distinctive mark on presidential administration, including significant use of social media, courts face new questions on how a president's words might affect judicial review of his agency's deeds. And of course, the decisions that courts make today will affect not just the current president, but future presidents as well. Now, as with all of our discussions today, this discussion centers around a paper prepared by one of our authors. And most of the papers are available on our website. If you go to our main page this morning, you'll find a link on the top of the page to the event site, which in turn has the list of all the articles. For our first panel this morning, Professor Richard Pierce has written a paper that considers several ways in which courts might respond to high-profile administration policies and the ways in which the court's responses may or may not preserve the president's power to take actions needed to execute effectively the powers conferred on the president in Article 2 of the Constitution. And so it's my pleasure to introduce our first speaker now. Professor Richard Pierce is the Lyle T. Alberson Professor of Law at George Washington University. One of the nation's leading scholars of administrative law and regulatory practice for 40 years, he's the author of the Administrative Law Treatise and co-author of a leading administrative law casebook. Among his many honors, he is a senior fellow at the Administrative Conference of the United States. Thank you, Professor, for joining us today.
Thanks, Adam. It's a real pleasure to be here. I'm one of Adam's real fans. I think he does a great job of putting together these programs, and particularly impressed with the wide range of perspectives that people bring to bear. What I've done is just looked at, I was troubled by the potential that we could see some real problems as a result of a couple of characteristics of President Trump, and so I then looked at half a dozen different contexts in which those characteristics could prove problematic, and came away reassured that I think we can deal with them in an acceptable way. So the two characteristics that are problematic, potentially problematic to me, are first his tendency to develop powerful animosity toward individuals and groups, and then it's actually a point of pride that he has emphasized many times, that he's vindictive. He then goes after anybody who criticizes him or anyone who has caused him to be angry. Well, if he's allowed to do that in his capacity as president, that has the potential to threaten some of our most important societal values and our most important values of our legal system. So what can we do about it? I think it's very important that the courts do everything they can to keep him from being able to act based on those dual traits of animosity and vindictiveness. But it's at least as important that he and his successors have to be free to exercise all lawful Article II powers. That's not going to be easy to do, but I'm cautiously optimistic that the courts can do it. And the first context I look at is the travel bans, the 3 different travel bans. And here we've got an action which ordinarily would probably elicit no review at all, or if any review by a court, a very light-handed review. And yet, because the travel bans were directed at predominantly Muslim countries, and because President Trump has expressed his animosity toward Muslims on many, many occasions and had said many times that he wanted to keep all Muslims out of the United States, there was the concern that this was actually a Muslim ban. So the third of the bans elicited an opinion from the Supreme Court, actually 3 different opinions, but the majority opinion looked at the powerful evidence that suggested that this could have been an action that was based on constitutional motives, that is animosity toward the members of a particular religion. But after looking at that evidence, wound up concluding upholding the action because it also had characteristics that provided pretty strong evidence that it was based on permissible national security grounds. In particular, it was based, the third travel ban, unlike the first, which was immediately after he took office, the third travel ban was the product of a 7-month-long multi-agency study. By the time it got to the Supreme Court, 3 of the predominantly Muslim countries had already been removed from the list, having availed themselves of one of the many exceptions and waivers. The policy had provisions that allowed for exceptions and waivers, and so the court said, yeah, okay, we're gonna uphold it as a lawful exercise of national security powers. And then, let me generalize from there just a bit, because actually there are many, many cases that go back a century or more, Supreme Court opinions in which the court has said, here are the normal rules that apply to review of presidential actions or actions taken by agencies, and then has added, but in the rare case where there's powerful and particularized evidence of bad faith, then we will depart from the normal rules and we'll look at other evidence, specifically that evidence of bad faith. And by bad faith, what they're talking about is a situation in which if the action taken by the agency, or by the president in this case, were taken for the reasons given by the government, then it would be entirely lawful. If, however, the action was taken for another reason, then it would be unlawful and indeed almost certainly unconstitutional. And so what the court has said in many contexts is we will look at powerful and particularized, we will look at evidence beyond the record whenever we are provided by the petitioners with powerful and particularized evidence of bad faith. And that's consistent with the way the court responded to the third travel ban. And I think it's, we're going to see a lot of that. I'm not particularly troubled by that particular context where the result of the determination that there was enough evidence of bad faith to be willing to look beyond the record was just to look at publicly available existing statements of a government official. I don't see a whole lot of harm in that. I see a lot more potential for harm in some of the subsequent actions that the Supreme Court has just now been getting into, where the evidence of bad faith is used as a justification to try to cross-examine an agency decision maker or to get discovery against an agency that includes material that falls within the deliberative process privilege. And I worry about those because those are extraordinary remedies that can cause real problems across government by deterring people from engaging in candid provision of advice to presidents and other senior decision makers. So I think the court is going to have to be very careful in terms of figuring out what it takes to qualify as powerful and particularized evidence of bad faith sufficient to justify cross-examination of the decision maker and or broad-based discovery against the agency. So the other context I looked at, I looked at the challenge to the AT&T Time Warner merger, which a lot of people thought was actually based on Trump's off-stated animosity toward CNN, and CNN was one of the main players in that merger. And so what's going on there and how much concern should we have about it? Well, I concluded that there wasn't much reason for concern about that context at all. First, the action was taken by the Department of Justice, not by the president. And the Department of Justice has only the power to challenge a merger in court. It doesn't have the power to say yes or no with respect to any proposed merger. So it challenged it in court. Well, once it challenges it in court, then you go to a federal district judge, and the federal district judge, Judge Leon, certainly did a very comprehensive job of deciding that, actually against the administration. Now we're going to see what the Circuit Court of Appeals does. But my point is that we're only talking about if anybody was tainted there by bias, it was the prosecutor, the head of the antitrust division, who had, before he had taken office, said he didn't see any problem with the merger, and then after he took office and was working for somebody who'd expressed a lot of animosity toward one of the parties to the merger, then saw it a different way. Well, that's ambiguous evidence that suggests the possibility of bias. But if so, it's the bias of a prosecutor. And the court has long held that the bias of a prosecutor does not and cannot taint the ultimate decision. We're concerned about the bias of decision makers, not of prosecutors. So then I looked at the next context that suggested potential problems, where President Trump engaged in a lot of actions that showed both a very powerful antipathy toward Amazon and the owner of Amazon, who's also the owner of the Washington Post, and had urged both the Postmaster General and this newly created task force to increase the rates that are charged to Amazon. So why was that? Well, again, it's ambiguous. There's lots of reasons to believe that we need to change the basic financial bedrock of the structure of the Postal Service. And probably that's going to include and should include some increases in Amazon's rate. But was it instead just motivated by his off-stated animosity toward Amazon and the owner of Amazon? Well, even if it was, I'm not terribly concerned, because neither the Postmaster General nor the task force can increase postal rates. That can only be done by a 5-member commission, 2 members of which have to be members of the opposite political party. And then that commission decision is subject to judicial review. And when you look at the way that the D.C. Circuit approaches review of the decisions of the Postal Rate Commission, they're pretty careful. So I'm not terribly concerned about that one either. So then we get threats to remove officers who are not personally loyal to the president, and there's been a lot of them. In most cases, they don't implicate constitutional values. They might be good, they might be bad, but if he removes, as he did, the Secretary of State, well, that doesn't get us into constitutional values at all. It can get us into constitutional values in some other contexts. One is where we're dealing with people like administrative law judges and administrative judges who perform exclusively adjudicatory functions, and so the concern is that we wouldn't want, I hope we would not want the head of an agency or the president to be able to remove these adjudicatory officers. And this is still a work in progress. The Trump administration, through the Solicitor General, argued to the Supreme Court that the Supreme Court should either hold unconstitutional or at least give a very narrow reading to the provision of the Administrative Procedure Act that restricts the power of any agency to remove an administrative law judge. The court decided not to address the issue at all, that it wasn't appropriately raised in that case. I'm cautiously optimistic that the courts will continue what's now a long line, a century-old long line of cases in which they distinguish between executive officers and officers who have purely adjudicatory responsibilities, and will continue to uphold any statutory restrictions on removal of such officers, adjudicatory officers. My biggest concern at the moment is about the status of immigration judges. They're under tremendous pressure to say no in all asylum cases. They get that pressure both from the former Attorney General, the acting Attorney General, and from the President. And they are not subject to any restrictions, statutory restrictions on removal. I'm hoping that I can at some point help convince the Supreme Court to overrule its 1955 opinion in Marcello v. Bonds and reinstate its 1950 opinion in Wang Young Sun, and use the Due Process Clause as the basis to protect adjudicatory officers from potential bias created by heads of agencies and or the president. And of course, there is the question of whether he can remove an independent counsel. And frankly, I don't much care, because I think the political constraints there are far more powerful than any legal limits could be. Then there's the threats to remove clearances. He's already removed one, and he's threatened to remove the clearances of at least 9 other former executive branch officials who have criticized him. And that concerns me a lot. That, again, is a work in progress, but I'm optimistic based on some of the case law in analogous contexts, particularly Webster v. Doe, where the court held that courts cannot review a decision to fire a CIA employee, but they can review it on a limited basis if the employee makes a credible claim that the firing was based on an unconstitutional motive, and certainly that would be a potential basis for a court to intervene, and in any case in which it's clear that the president has removed somebody's security clearance because of their criticism of the president. And then we've got, of course, his famous agenda to try to rescind, well, as he put it, every rule issued after 1960, and 70% of, and well, first of all, I'm not as concerned about those, because very rarely does that implicate important constitutional values. They're important, but they're not of the same level of importance. And second, frankly, as I think you will hear later today, in fact, in the next panel from Rob Glicksman and Emily Hammond, he's been just incredibly unsuccessful, and I think he'll continue to be completely unsuccessful in his efforts to further that part of his agenda. So here are things I'm concerned about. Destruction of valuable institutions. The Department of Interior and the EPA and the State Department have been tremendously damaged as institutions in this first couple of years. It's going to take decades to rebuild them. And then I'm concerned about destruction of public confidence in other valuable institutions, the Department of Justice, the FBI, where about half of the country now thinks that they're illegitimate. And then again, that's going to take us decades to rebuild that. So I'm very concerned about that. Now, I presented this paper at a workshop that Adam put on a few weeks ago, and I got a lot of pushback from the other participants in the workshop. And the consensus, indeed the near universal consensus, was I was too optimistic, that there were a lot more problems than I had recognized. And that took 2 forms. One was people said, well, there is no meaningful judicial limit on exercises or abuses of the pardon power. the power to waive or not to waive rules, and exercises of enforcement discretion. And I have to admit, I do not see good limits on those powers, so they are, I think, matters of great concern. And people also pointed out that I was relying very heavily on the continued willingness of the courts to limit the conduct of the chief executive. And I confess, I am relying very heavily on that. But I don't think I'm relying on it too much. I think that the Chief Justice's characterization of judges is far more accurate than the President's characterization of judges. And I don't have any doubt that even though he may view some of these new appointees as Trump judges, that they're not going to behave as Trump judges. They're going to behave like all judges. They're going to have a particular philosophy that they will be applying, but it isn't a pro-Trump philosophy. And so I really continue to have faith in the judiciary as providing meaningful checks on potential abuses of the type that concern me. So that's all I got to contribute. Thank you.
Thank you.
Very much. Dick, I do have to quibble with one point you made along there. The center has a perfect record of never coming anywhere near consensus in any of its discussions. And if it did, I'd find ways to disagree just to make it more interesting.
I thought there was a consensus that Pierce was wrong.
Well, I'll leave that one alone. Well, we're very grateful to be joined by three more panelists to comment on Dick's paper and offer further thoughts on the subject. We thought we'd do it in alphabetical order. Now, speaking as somebody with W for a last name, I just want to say alphabetical order is completely arbitrary and capricious, but it's just maybe the best way to do it. So we'll begin with Robert Bauer. Bob is the New York University School of Law's professor of practice and distinguished scholar in residence. From 2009 to 2011, he served as White House counsel to President Obama. We're grateful that he can join us today to offer his own unique insights on the relationship between the presidency, administration, and the courts. Bob?
Well, thank you very much. I will try to put the concerns that I have, and they're somewhat keener. I probably fall in the camp of those who are less optimistic, within what I think are sort of broad trends of constitutional and institutional development. And I'm going to be very clear at the outset. I'm a Democrat, and I worked in the Obama administration, but I do see this in sort of broad, in sort of a broad sweep of time here. And so I'm going to note as necessary where I believe the points that I'm making here are ones that would attract or could attract bipartisan support. This is not an attempt on my part to add to the chorus of voices denouncing various aspects of the current president's conduct. So as I understand Richard's very interesting, thoughtful, and I think important paper, he wants to see some very difficult goals in somewhat in tension with one another balanced. That is to say, he would like to see, on the one hand, the courts preclude President Trump from acting, or any president, acting on unconstitutional bias with animosity toward groups and individuals, but at the same time, not do anything to prevent this president or any other from taking lawful actions not rooted in bias, and in any event, not create precedent that it could unduly limit the discretion of any one president's successors. The concern that I have is that when we talk about Article 2 powers, what is lawful in the president's discharge of responsibilities under Article 2, we have to confront the extraordinary growth in the power of the presidency over time. And I am reminded of a speech, which I think is now in print, that Stanford law professor Michael McConnell, formerly a judge on the 11th Circuit, gave some time ago, which was entitled, and I think this sums up his view, Our Elected Monarch. And his concern, by the way, was that we've seen the development in the growth of this office, the powers not only ceded to the president, but increasingly claimed controversially by presidents. We've seen this over time, although he tends to see this disturbing trend, as he sees a disturbing trend, and I tend to share his concerns, as having been accelerated in the George W. Bush and Barack Obama administrations, and now probably, you could say, liftoff with Donald Trump. I would like to refer to it as a concern at its most extreme expression with what I call the demagogic presidency. And when I use the word demagogue, I don't mean it as a term of opprobrium or an epithet in the normal political discourse. I mean demagogic presidents as understood by the founders. As has often been recognized and commented upon, the word demagogue appears both in the first and the last of the Federalist Papers. It was this extreme concern, or a strong concern of the founders, that a certain style of political leadership that we can characterize as demagogic political leadership could one day take hold in a presidency. And what would that demagogic leadership be? It would be a leadership that is based on sweeping claims about the authority of the office, rooted fundamentally in the characteristics in the person of the president, who forms a particular bond with the public, a certain troubling bond with the public, and that ultimately expresses itself in the president's pursuit of ruthless self-interest and recklessness in the choice of means, which includes systematic falsehoods and other, what we would call unfortunate, sometimes lawless, sometimes unethical approaches to accomplishing the president's ends. So it's a presidential leadership style. I don't believe that we've seen the end of the risk that is presented for the presidency, particularly as the presidency has developed now over a period of time with the election of Donald Trump. I think that the Trump presidency, ceding all that is unique about it, that the Trump presidency was a train wreck waiting to happen as we had the confluence of two factors, an extraordinary growth in the power of an office and the complete breakdown of any kind of rational selection process. And now we have a president who comes to office with no experience in government and whatever other weaknesses, if you will, of character or approach that we might identify. Moreover, at the same time, we have what Sam Zakharoff and Rick Pildes famously referred to as a separation not of powers but of parties, which means increasingly that Congress as an institution, if it is aligned politically with the president, does not function appropriately in upholding its end of the constitutional bargain as an institution. Let me give an example. The emoluments issues that have been raised in the Trump administration. For almost 2 years now, Congress, which has specific constitutional authority to affirmatively consent to the acceptance of foreign emoluments, and surely nobody disagrees there are at least some questions that have been raised, even conceded by the president when he organized his business interests at the end of 2016. There are some questions presented about the emoluments clause and the degree to which this president's organization of his business interests is consistent with it. In 2 years, Congress has exercised absolutely no oversight whatsoever on this issue. I'm not aware, certainly, of any hearings. I'm not even aware of any leadership inquiries, letters, questions, for example, about the particular ethical requirements that the president said that he would follow, both within his organization and with an outside ethics advisor, to assure, for example, that there were not foreign emoluments issues implicated by the way he continues to sustain his business interests. Why? Because that congressional majority believed that it was in its political interest not to raise that issue, not to challenge the president when there were other larger concerns, larger political and legislative concerns that it had. And I want to stress again, I don't believe that this separation of parties versus powers question is one that is going to bedevil only the Republican Party. So this is not a partisan point, and I want to stress that. So I move from that institutional context, a powerful presidency, an over-empowered presidency, the now arrival of the demagogic presidency, the incapacity of Congress as an institution in effectively policing a proper balance between institutions and drawing limits against presidential overreach. And I just want to make a few brief comments and make sure my watch is telling me what time it is. A few very quick comments about how this plays out over some of the examples that Professor Pierce raised today. So, for example, Professor Pierce writes about the president's removal power. The vast majority of removals of officials and/or threats to remove officials have no potential to empower the president to take actions that threaten constitutional rights. And I think that's correct. But those removals that could have that potential really count. And I think Professor Pierce noted that at the end where he talked about the concerns with presidential exercise of prosecutorial discretion. And I think that ties very much into my worries that here, think of, lock them up. Why is it that you haven't prosecuted the Democrats? Why is it that you haven't prosecuted Hillary Clinton? It seems to me that that is an enormous area in which the president's claim of constitutional authority is one that is going, particularly in light of Congress's periodic, sort of passivity in these matters, is going to require active intervention by the courts. Second example, security clearances that have been revoked. Once again, let me say that I agree with Professor Pierce. We can't answer, and I'm quoting from him, definitively the question of whether the courts can stop President Trump from taking blatantly unconstitutional actions while simultaneously preserving his power and the power of his successors in office to take all lawful actions needed to exercise the powers vested in the president by Article 2 of the Constitution. But that's what presidents constantly challenge. They constantly challenge in a variety of ways the boundaries of what we would define to be the lawful actions needed to exercise Article 2 powers. While it may be that Doe versus Webster, which involved the CIA director's discretion under a congressional statute, gives us some hope that in cases of clear-cut bias, the courts would step in, I'm a little less sanguine than Professor Pierce because Doe versus Webster, of course, concerns an agency official's discretion and not the broader constitutional claim, not under a statute, but under the Constitution that the president might make. And then last but not least, I want to mention the CNN, AT&T, Time Warner issue. It seems to me that whether, in fact, the decision maker in the end might be free of a clear-cut taint of bias doesn't end the inquiry as far as I'm concerned, or I think as far as the court should be concerned, because the use of the power of the state to harass in effectuating a president's bias or prejudice is, of course, something against which it seems to me in a constitutional order we have to actively guard. And so it may be at the end of the day, and yesterday apparently the Court of Appeals in the oral argument in this matter put the government to a pretty severe grilling. I wasn't present, but the press account certainly suggests that was the case. Nonetheless, to have the ongoing effort of an administration presumptively or by suspicion, however you want to look at it, ongoing effort to pursue through the actions of the Department of Justice or other administration agencies a vendetta against the press is something that I think we need to worry about, short of whether in the end the president will be successful. And that brings me to just the following 3 points. Donald Trump, and I think Professor Pierce is right about this, has fallen very short of some of what he would have liked to accomplish, like, for example, in the regulatory process through the actions to deregulate that he apparently is quite committed to. The next Donald Trump might be more skillful. The next Donald Trump might be more experienced. And so I think we have to look at what it means for the constitutional order that you have an effective Trump going about doing the kinds of thing we're talking about today. The final note I want to make is, what does that mean for the courts? It means I would think that in striking the balance that Professor Pierce notes at the outset, I think the courts in the meantime have to be much more concerned with drawing the line against presidential bias, constitutional misconduct, and perhaps less concern about cabining presidential discretion, a discretion that in any event presidents inflate, and much less concern about setting the wrong precedents for future successors. That may work itself out one way or the other, but I think the time has come in any event within the broad institutional development that I discussed to start laying some serious markers down and resisting this heavy expansion of presidential power. What came to mind, and this is truly my last comment, is, of course, the risk that the courts run is they overreach in turn. But it seems to me that is a problem that we can correct for in a variety of ways, and it is certainly not, it seems to me right now in the current state of American constitutional law and practice, actual experience with the way our constitutional order is functioning, it is not the principal problem that we face. Thank you very much.
Thank you. And our next speaker is Michael Greeba. Michael is a professor of law at the Antonin Scalia Law School, where he teaches constitutional law, administrative law, federal courts, and other subjects. Before joining the law school, he was for a long time a fellow at the American Enterprise Institute, where he wrote and studied constitutional law and structure. In fact, for many years, worked alongside another great student and teacher of constitutionalism, Walter Burns. Among Michael's many books and articles is his study of federalism, The Upside-Down Constitution, published in 2012 by Harvard University Press. Professor, thank you for joining us today.
Thank you for having me. Like I think, Bob, I'm more concerned about institutions than this president's personality. And in particular, I share the concern about the stupendous growth of executive power, which has been going on for 40 years now under presidents good and bad. I think you can overstate the apprehensions that arise in that context. I mean, a tweet storm doesn't mean that anything actually happens, and there are all sorts of institutions that provide some pushback and protections, the deep state, the media, the resistance, call it what you will. But eventually, everyone's search for checks and balances turns to the envisioned institutions like the Congress and the courts, and I think things look very bad at both fronts. So Congress looks much worse to me than 2 years ago. I mean, it was bad enough for a once proud political party to suffer the victory of a blowhard who was barely a Republican. But there were at least many members of Congress back then who didn't owe him anything, and so you had some reason to think that Congress might actually assert or reassert itself vis-a-vis the executive. That obviously hasn't happened. It's Donald Trump's party now, and as Bob just mentioned, it's a separation of parties, not separation of powers, and in that context, the president always wins. And so my thoughts, like Dick's, turn to the courts. And perhaps unlike Dick, I don't think the existing body of law is remotely sufficient to check the assertion or accretion of executive power. If it were, we wouldn't be where we are. Let me pick up the conventional distinction between administrative government and presidential government. There are reasons to worry about administration. I mean, I worried about the administration's discretion under the Affordable Care Act under the Obama administration. I continue to worry about it even now that my friends write the guidelines. Same with the Education Department, the CFPB, and on and on. There's been a vibrant debate about what, if anything, one might want to do about waiver authority and regulatory dark matter and policy making by proposal and all the rest of it. I'll sidestep those issues for today. I'm happy to talk about them, but I'm not going to elaborate because I think the new normal there is the old normal. If anything, my general impression is that there's a bit more normalcy emerging at most, if not all, agencies, right? So Dick worries about Trump-appointed FTC administrators might arbitrarily delay or derail a merger if the president doesn't like one of the subsidiaries there. I think it's quite unlikely, actually, in any event. This president will not do what a previous White House occupant did, which is to order an independent agency to implement Netflix's agenda and then find some reason in an ancient statute why that might be okay. I'm not necessarily against that form of presidential government. My point is simply that this president is unlikely to do it, not because he has constitutional scruples, he doesn't, but he doesn't care, right? Unless he wants to settle some score. So my principal worry arises in areas of presidential government where the president does care. And as it happens, those are the areas that existing statutes place directly under presidential control: trade and immigration. Two examples from the trade area. Can the president unilaterally withdraw from Nafta, as he has vowed to do, unless Congress now approves his renegotiated bargain? Nafta itself allows each party to withdraw on 6 months' notice, in which case the parties are free to ramp up tariffs to WTO levels. But large parts of Nafta, as I understand it, would remain in effect under that scenario, including the arbitration mechanism. And more important, I doubt that the president can unilaterally rescind the NAFTA Implementation Act. But I'm not at all sure about that answer, and even less certain what the courts might do. I'm quite certain that in the event the administration would push very hard on sort of Curtis Wrights-ish assertions of executive authority, and there'd be a brief from the sort of congressional never or always Trumpers that there's nothing wrong here, and so no worries. Two, do we believe that Section 232 of the hilariously named Trade Expansion Act, which is the basis of the president's various tariffs, that is constitutional? Under the statute, the president may invoke the statute and impose tariffs upon a finding by the Secretary of Commerce that certain trade practices endanger national security, which under the statute as it's written could mean absolutely anything. And then it permits the president to impose tariffs at any rate, on anything, on anyone, import quotas, rescind trading licenses, the works. This isn't a hypo. This is a real case that's being litigated in the Court of International Trade. And the plaintiffs are hemmed in by a ton of very lousy precedents and doctrines, both on Section 232 itself and on a whole bunch of other things. So sorry, the statute, you could argue, mumbles enough magic words to pass an intelligible principle test. See Yakis versus U.S. Sorry, there's no enhanced judicial review for delegation purposes when you're talking about a tax versus a regulation. That's Skinner versus Midwest Oil. And in any event, this is all Youngstown 1. All executive power plus specific congressional delegation. So I'll give you an argument why you might think that Section 232 as written is actually unconstitutional and might go like this. One, this statute has no limits on executive discretion, either on the trigger to invoke executive measures or on what the president may do afterwards. And that takes you a million miles outside Hampton. Two, the delegation worries are heightened here because there's no orderly administrative process. Three, delegation concerns are further heightened because the president's proclamations, that is to say the tariff orders, are judicially unreviewable under the APA or otherwise. And four, there's a process so-called for tariff exemptions, but the secretary can act or not act on applications. There are some 20,000 pending now, as he pleases, and the decisions are, again, unreviewable. So the president has unbridled authority to punish or reward private actors across the entire economy. Is there a case that goes like that? Yeah, Schechter Poultry. That reads like that, but I'm not sure I would try that in this context. Much more likely, you'll get a ruling to the effect that delegation concerns don't apply at all to foreign commerce. So bottom line is that the president is messing with the entire United States economy and hundreds of private enterprises in a law-free zone. And I'm worried about that before I worry about bigotry or obsession with CNN. That brings me to immigration, which is Dick's principal example. Same pattern in some ways as in the trade area, right? Exceedingly broad executive authority vested and in or delegated to the president, complete congressional abdication, even when there is a sort of bargain that seems perfectly tolerable and reasonable, seems within reach, but they can't get there. But there are also differences, especially with respect to the courts. So I agree with Dick on one point. Courts shouldn't crank up sort of one-off doctrines to rope in one idiosyncratic precedent, especially not at the price of constraining future presidents in the legitimate exercise of their powers. And unlike Dick, perhaps I'd cite Humphrey's executor as an example. But what the lower courts have been doing now in the immigration area on standing to sue, on reviewability, on the scope of injunctive relief, looks entirely like that. It's stuff that I've never seen, let alone taught before. And I also think that applies to Dick's theory that the president's bad motives should be a central consideration in determining the constitutionality of an otherwise lawful travel ban. I mean, the plaintiffs there in that case had exactly one supposed precedent. That's this Miss McCreary case. And even that case, besides being ludicrous on its face, is on life support. And it was inapposite in several ways. So I think at the judicial front, this is almost as depressing as our Congress, and here's why. I think if you think about institutions rather than bigoted tweets, and if you think, as I do, that there is not remotely enough law and not remotely the right kind of law to constrain executive government, then Mr. Trump is actually a moment of great opportunity, right? So under a Democratic president, democratically appointed judges and justices will be in the tank for the administration, as they have been for 8 years and counting. And any conservative justices attempt to reimpose some limits will look like a coup d'etat. In contrast, when you have a sort of nominally conservative but substantively unhinged president, liberals might actually come to rethink their constitutional commitments. And between them and conservative justices, especially including the new appointees, you might be able to rebuild some judicial consensus for more lawful government with doctrines to match. I fear that that opportunity is slipping away because as the lower courts are cooking up these "we too are the resistance" opinions, the Supreme Court will rope them in. And so to all concerned, it looks like business, partisan business, as usual. And that, in a nutshell, is my biggest fear.
Great. Thank you, Mike. And our fourth speaker on the panel is Paul Verkyle. Paul served as president of the College of William & Mary and as dean of the law schools of both Tulane and Cardozo. He's a life member of the American Law Institute and the Fellows of the American Bar Foundation. Most recently, he served as chairman of the Administrative Conference of the United States, where he remains a senior fellow. He, too, is one of the nation's leading scholars of administrative law, author of a leading treatise, Administrative Law and Process, and most recently, author of the book Valuing Democracy, we value that too, Valuing Bureaucracy, published recently by Cambridge University Press. Paul, we thank you for joining us today.
Thank you, Adam. Glad to be here. So I'm going to focus my remarks on Dick's last slide, which is his biggest concern, destruction of valuable institutions. But in order to get there, I'd like to talk through what both my predecessors, Bauer and Greeba, have discussed, which is the institutional issues at stake in this current setting. And the way to do that, I've decided, is to say, since I'm in this location, what would Nino think? And knowing Nino, having known Nino so well and having had the good fortune to succeed him many years later in the chairman's job at the administrative conference, I think I have a pretty good fix on it. But I wanted to add a Regulation Magazine article just to substantiate it. In 1981, the game has changed. That's a very important, insightful thing. And let's assume that Justice Scalia, Nino to us, was around when Trump started to make these decisions. How would he review it based on his experience? If you read that little article, it's very important. Two ways. One is that he was worried about finding appropriate people to appoint. He had told a story about William Saxby in the Ford administration, who said, look, my problem, I can't find good people to come into the Justice Department because Republicans, they don't want to serve. They just want to make sure that Democrats don't serve. So that sort of notion, which they've gotten over, and I must say, thinking about then and now, we ended up with a deregulatory agenda under President Reagan, headed by Vice President Bush, who we've just seen off in a grand way. And every regulatory action was carefully monitored. The people who were selected for the positions in the agencies were held to account. I remember Jim Tosey telling me that he met with Vice President Bush virtually every Saturday morning. Jim, you're back there. You can affirm it. Because that's how much interest the administration had in getting this right, from their point of view, the deregulatory actions. So there was a very powerful force at work, which was the appointment of good people. That's one change we have today. The other interesting point from the article is that he said the game has changed, which means watch out what you wish for. We don't want the bumpers amendment. As you may recall, back in the day, the Bumpers Amendment, which was the Democrats' favorite, the Republicans were certainly neutral about, provided basically de novo judicial review of agency action. He understood quite fully that when our guys are in their room, we don't want to lose our advantage. We don't want to, he says, score points for the other team. Now, take that a little further. This is prior to Chevron. Chevron doesn't get decided until after Judge Scalia is on the D.C. Circuit in '84. But the truth is, he loved Chevron. He loved Chevron for very good reasons, because the agencies have to operate. And in a politically neutral way, Chevron was decided, after all, by Judge Stevens. It was a gift from the liberals to the conservatives. And so it should work both ways. And certainly today, those Chevron skeptics might wonder whether they're in the right pew or on the right side. Now, it's not just Chevron. Of course, it's State Farm, which is much more important than Chevron, because that's how you stymie deregulation, through the requirement of process in rulemaking. But there's also cases such, interesting, Dick brought up the question of the independence of ALJs. I mean, now we go back, and the independent agencies, we go back to Humphrey's executor. I think you wanted to do in Humphreys, maybe, but Scalia never wanted to do in Humphreys. He actually resisted that attempt. Now, and he also resisted Schechter, I have to say that too. There was efforts, to revive the non-delegation doctrine in cases that came to the court, which he didn't share in. So I think it's fair to say his view, while he had political notions very strongly, for the court, he saw the difference between the court and the Congress. And the courts, I do not think he would should be as compliant as the Congress is towards a president, and particularly this president. Now, where we are is in a remarkable state. I never thought I'd have to learn a new word at my age, but kakistocracy is what we have. That's government by the weakest. And the problem is that it didn't follow the sort of pattern of the Reagan years, which is to find good people. Of course, the president wasn't prepared to govern when he came in. And indeed, his Rolodex was empty except for cronies who were totally unqualified, as we have, I think, increasingly seen, and there's no backup and I don't know what the White House Personnel Office does, but it certainly is not finding a deep bench anywhere. And you would think, once you get the gist of the job, that wanting good people to serve would be your first requirement. We really need, if I may say, we need a Federalist Society for the bureaucracy, something to get some people that can know what they're doing and perform legally. Now, if they do, I think the courts will provide some resistance. As I say, I do think, U.S. v. Nixon, I hope people are rereading the case, not because I expect an impeachment or even would desire that. I think that would be a mistake, too, if the Democrats went in that direction. But still, it's just a principle that we have a court. And why do you go to work every day if you're in the court, if you can't stand up at the right moment? That seems to me to be the ultimate question. Going back now to Dick's point of destruction of valuable institutions, I don't have all that much time. I am going to borrow from my book, Valuing Bureaucracy, which takes the position that the most important thing we have, which is indeed an asset, a public asset, is our professional government, people who know how to do their job and do it well, and will serve under either administration and be honorable about it. And there's a panel later today taking that civil service question up more directly. But my experience has been that the agencies are suffering because the talent is not respected by those at the very top. We have a president who is a self-made man who admires his creator. I actually stole that from somebody, but I like to use it. Ted Sorensen said that once. So when we have this situation, other institutions don't seem to be important. And we see the most dramatically in the Department of State. But even before we get there, and I want to finish with a comment about the State Department. Before we get there, if you've read Michael Lewis's The Fifth Risk, have you had a chance to see that? Well, Michael Lewis, who does these amazing reports and studies people and situations, goes to the government at the beginning of the Trump years, and especially goes to the Department of Energy, for example, where they were prepared for the transition. By law, there's transition. They had 40 parking spaces available for the Trump transition team. They had all the tables, all the preparations. They were sitting on one side, and no one shows. No one shows. This happens not only at Energy, all the other agencies. There was no transition work of any significance at all. People didn't show, let alone listen. And they didn't even meet. And of course, the head of the Department of Energy doesn't really know a lot about his job, but he didn't really meet with one of the most experienced, his predecessor, one of the most experienced energy secretaries of all time. So we had this gap, and Michael Lewis, the fifth risk, by the way, is the chief of staff to Ernie Muñoz, to Secretary of Energy, said there were 5 risks. North Korea, the grid going down in the United States, others. But the fifth risk, he said, was operations management. In other words, the government, how it runs and can it run. So that's the fifth risk. And it really does nail the point that we didn't have, really for the first time. It's not having someone come into government has the opposite views of the prior. That happens all the time. But we didn't have someone prepared for the job. Now, my final concern is just what does it do to the bureaucracy, to the people who work here, who work very hard and in the main on, and I must say, that's why I wrote this book, because after 5.5 years of serving as chair of the administrative conference, I've met an awful lot of good civil servants. Some political, most of them not. And I really valued the institutions that they valued for that reason. The State Department, particularly for a former college president, it really does trouble me, because Foreign Service officers who know something, they're like faculty members at a good university. They know their subject. They know the languages. They know the culture. They've been in the communities. They've suffered oftentimes over years learning about the many countries of this world where we have an interest and need to know what's going on. They're leaving in droves. The Foreign Service Officers Commission group is dwindling. The number of people taking the Foreign Service exam has dropped off dramatically. And we've lost, it would be like a good university losing, I like to think, the departments of ancient languages and things that are just irreplaceable. And other subjects. I'm not worried about law and business. There'll always be subjects like that. But I'm talking the deeper subjects, the one if you're a president of a university, you want to know the answer to a really hard question, you can call someone on your faculty who study that subject, and they'll give you a good answer. That's the way government should operate. We have people who know those things, and we don't want to lose them. We've spent so many years building it, and I think, just to conclude, I would say that that's our biggest risk and our biggest challenge. And I think Dick was entirely correct. Whatever else he may have been, maybe too optimistic on the courts, I don't know for sure, but I do think he's right on destruction of valuable institutions and the lack of public confidence. And the problem of getting good people into government in this environment is a real national crisis. Thank you.
Thanks, Paul. Dick, do you want to take just a minute or two to respond to anything that's come up so far?
Sure. Let me begin by saying I agree with almost everything that Bob, Michael, and Paul said. I don't see big differences there. I just wanted to make 2 quick points. One is the Chevron point. I've always found this humorous. I mean, what was Chevron? I lived through all this. So what we have is Ronald Reagan, a conservative Republican, who appoints Ann Gorsuch, another conservative Republican, to run the EPA, and Ann comes up with this great idea, I thought, of implementing new source performance standards on a bubble basis. You apply it to the whole plant instead of doing individual. And so she changes that policy at EPA, and then it's reviewed by the D.C. Circuit. Somebody named Ruth Ginsburg. You may have heard of Ruth Ginsburg. She's on the other side of the aisle and quite different ideologically. And Ruth says, I don't like this, and reverses it. And then it goes to John Paul Stevens, last I heard, a Republican, who says, well, you know, I think that these kind of policy decisions should be made by politically accountable, presidentially appointed and removable agency heads, and not by those of us who are the least politically accountable, the judges. So I'm going to go with the conservative policymaker, Ann Gorsuch, and overruling that liberal who, okay, and that's how we get Chevron. And then Scalia is the biggest supporter of Chevron. He is also the least deferential of the justices. The biggest critic of Chevron among the justices is Steve Breyer, who's upholds agency actions more frequently. Okay? And then all of a sudden, I find people on Capitol Hill shouting about Chevron's either the end of the world or the beginning of the world. You know, if it's ever overruled, everything will, the country, well, it needs to be overruled or the country. I mean, what the hell are you talking about? We're talking about the difference between Chevron deference and Skidmore deference. And for those of us who like to spend a lot of time arguing about how many angels can fit on the head of a pin, this is worth some time. But how the hell it got to be a big I don't understand. But the other point is a more important, broader point that I actually agree with all three of the commenters that we have a problem that goes way beyond Trump. It pre-existed Trump, it's going to exist after him, and that is the constant accretion of power in the presidency, and that causes lots and lots of problems. So what are the sources? There are a lot of sources, but one major source is we've lost the ability to legislate. If you don't have the power to legislate, then every president comes into office and says, I see a big problem. Well, in bygone days, I could have gone to the leaders of Congress and said, help me work this out. Today, you can't do that. It won't happen. It's absolutely impossible, okay? So you don't have any choice if you want to grapple with any issues but to act like an imperial president, because there's nobody else there to take any role, any of the traditional roles that they used to. So why is that? Well, there's a lot of reasons for that, but to me, the biggest single reason is the damn primary process. We're the only democratic country in the world that uses a primary process to select nominees to run for office. We've only been doing it since the 70s. It was a really bad idea, and it's coming back to bite us big time. I spend a lot of time on Capitol Hill. Every time I go to any Democratic or Republican member and I say, why don't you cross the aisle and talk? And they say, I'd be primaried out in no time, okay? So every Democrat has to move as far left as possible. Every Republican has to move as far right as possible. We need to get rid of the damn primary process. That, in turn, gradually can rebuild our capacity to legislate, which, over time, can reduce this phenomenon of the imperial presidency.
Well, Dick, I got to say, if I knew you were going to attack the primaries, I would have not only worn my Iowa Hawkeye cufflinks today, but I would have worn my socks and lapel pin too. Just a question. I mean, there seems to be a lot of agreement on the panel, so let me take a chance to disagree. Listening to the parade of criticisms that we've heard so far, I wonder how much of this that we're talking about actually is a significant change and not just a little more accretion of what we've had for decades and decades. And I know some of the panelists, including Dick just now, have said that, but I mean, so many of the criticisms about presidential overreach, presidential control of agencies, presidents pushing the boundaries of their powers, it's the same criticisms we heard during President Obama's administration, same criticisms we heard during President Bush's administration. You know, you hear complaints that there aren't good people serving the administration. There's lots of good people serving the administration. Elaine Chao, Jeff Sessions was a great appointee. James Mattis, of course, is a great appointee. That's on top of countless lawyers and policymakers serving in the agencies and serving in the White House, regardless of what you think of given leaders. There's lots of good people in the administration, and there's always been bad appointees. There's always been lackluster people in any administration. The bureaucracy feels undervalued, but of course that's not new. The bureaucracy always feels undervalued. It's why, Paul, you wrote a book years ago called Valuing Bureaucracy, right? This isn't a new complaint. I don't know, just the more I listen to the panel, the more I think maybe there isn't anything new here, that there's a change in tone. Obviously, President Trump's, his tone, his rhetoric is very, very different. But if all we're talking about is just a change in presidential tone on top of trends that long precede this administration, then is there really anything new here? Anybody?
Well, if I could just.
Yeah, please, Bob.
I mean, there's just, it's a very good question, and the answer, I think, is a complicated one. But let me just bring one example to the fore. I think it's a confluence of developments over a very long period of time. So I don't think that while each individual accretion might throw anybody or surprise anybody, when you look in the aggregate, then what you have is a series of both political, cultural expectations and institutional developments that add up to something that is much larger and more serious and more menacing than anybody anticipated. First of all, presidents come into office increasingly with tremendous pomp and circumstance and the expectation that they're going to bind the nation's wounds and they're going to, create a new day, and every problem that's identified ultimately is up to the president to solve. And there's some very good language in a book that Gene Healy of the Cato Institute wrote entitled The Cult of the Presidency that lays some of this on just the tremendous pressure in American politics to have presidents grab as much authority as necessary to solve what are sometimes such intractable problems that the power needed to solve them would, by necessity, be enormous in scale. So you have popular expectation that has just sort of grown to that point and is, of course, fed. I mentioned the selection process, and I just want to just draw one thing. It relates a little bit to this concern about the quality of our bureaucracy. But at the same time as we're conferring all of this authority on presidents, and I said this briefly before, we have a selection process which is completely open. Anybody can run. And frankly, we're now at a point, and I'll just say this as starkly and maybe oversimplistically as I possibly can, whereas it was once a telling point, a point in a candidate's favor to say, I have enormous amounts of experience, it is now far politically more advantageous to say, I actually have no experience. Not only that, I despise the government and everybody who works in it, and I'm going to go and I'm going to throw all the money changers out of the temple. And I think we're going to hear that rhetoric increasingly, and people who don't have the capacity or the wherewithal to run the government are increasingly going to be people who surge to the forefront in a system that is beginning to select for all the wrong qualities in the person who should be leading a powerful federal government. So I think that is new. I think that if you look at, I remember somebody once telling me, I really don't like, Richard Nixon, a Democrat, once said to me in 1968, said, I don't really like Richard Nixon, but he has a huge amount of experience. Now, and I may end up having to vote for him over the Democratic nominee. He said a lifelong Democrat. An unimaginable metric for any Democrat to apply today to voting for a Republican, or vice versa.
Anybody else?
Yeah, I want to start by just agreeing with you that most of the problems we're talking about are not unique to President Trump. They've been around a while, but they have been getting worse. Every year they get worse. And one of the easiest ways to illustrate that is to use a context that both you and Paul referred to, the appointments process. Ann Joseph O'Connell at Berkeley is the leading expert by far on the appointments process, and she maintains a regular data set where she shows what has happened in the appointments process for every administration over a 60-year period. And it's just gotten worse and worse and worse. You cannot appoint the people before your administration ends. It's the way we are now. And so that process, the process the appointment process itself has gotten worse every year for the last 50 years.
But Dick, I mean, I can't help but ask then, doesn't that in a way answer your own question about Chevron? You said, what's changed? Well, maybe nothing major has changed. Why did Republicans or conservatives change on Chevron? I mean, maybe it is just the long accretion of change. I mean, it's not partisan. If it were, conservatives would have opposed Chevron in 1993 rather than in 2013. Maybe it is, maybe the last point you raised about Chevron, it just reflects the sort of slow accretion of concerns about Chevron to the point where it reaches a tipping point, and suddenly a critical mass of people who once supported Chevron deference now see it the other way.
I actually, my take on that is very similar to that of my frequent co-author, Kristen Hickman, that Chevron is just a stalking horse for the non-delegation doctrine, that for some reason, people, they're not willing to talk about. Michael's one of the few people who's willing to talk about the non-delegation doctrine because it's been pronounced dead for a very long time. But Chevron is just a way of talking about unduly broad delegations of tremendous amount of power to presidents. But that's where the focus of attention should be, on things like Section 232, and my colleague Alan Morrison has brought an action challenging that under the non-delegation doctrine. The court has a non-delegation doctrine case before it this term involving the delegation of no standards at all of the power to make the sex registration program retroactive. There were no guidelines in the statute about that at all. So the court is going to decide whether that was a violation of the non-delegation doctrine. I think that's where the concern should be about the broad delegations, not about some silly review doctrine.
I do want to give the folks in our audience a chance to ask some questions. We have microphones in the room. There's people holding them, and they'll bring them to you. So please raise your hand. We'll begin, actually, you, sir, Richard, and then Ron.
So I just want to push back on one point that the panel made. I tend to agree with Eleni Kagan that the president, they come in thinking they'll have a lot of power over the executive branch. It turns out they don't have a lot of power over the executive branch. And I think that the idea that a president can destroy the credibility of a bureaucracy is probably way overblown. I think they're more than capable of destroying their own credibility. EPA, for example, you could say they have biased and non-transparent science, which I think destroys their credibility. Then you've got IRS, for example, targeting groups and even candidates, political candidates. So I think that, and there's a lot more of that goes on. I really think that the agencies have done a terrible job with their own credibility. I don't think this is so much the fault of a president.
Paul or anybody, any other thoughts on that?
There's no doubt that lots of agencies have had lots of screw-ups over the years, and that's a couple of good examples. In every administration, there are screw-ups like that. It doesn't, it's important to recognize that that's what they are. They're screw-ups. They're not the normal. That's not the way agencies act on a day-to-day basis. I deal with civil servants all the time. Most of the time, most of them are working very hard to do the right thing, and it's a very hard thing to do. But sometimes they screw up royally. I mean, the abolish IRS, or let's take away all IRS's resources so we don't have a voluntary and effective voluntary tax system anymore is, to me, about as sensible as let's get rid of ICE because we're angry about some of the things that ICE is doing. I mean, when you see a problem like that, you address the problem. You don't then use that as the basis to say IRS is evil, EPA is evil, ICE is evil, whatever the hell your latest candidate for evil among agencies is.
Paul, do you have any thoughts on that?
Well, I just wonder whether we can keep doing the same thing, which is assuming the agencies are going to run on their own and the president doesn't matter. I think we're running out of people who can run on their own. These SES, which is the key leadership in agencies, it's half retirable age. They're leaving the numbers are not good. I don't have them all in front of me, but I think you could check them with me. experienced people are leaving government in bigger numbers, and the worst thing is that they're not being replaced by good people coming in. Public policy schools, the key institutions who should provide leadership in the government for young entries, they're all going to contractors. They don't think of government. They go to McKinsey if they're, or other places. And they serve government in their own way, as it were. But we need people in government who make the decisions, who have taken the oath of office, which is awfully important, which contractors cannot do. And that's really another part of my whole story, and that the growth of contractors now is so great, and the need to, I think, challenge their roles, the inherent government function test and things like that, which don't get operated on, is even more important than it has been. And this, to your point, Adam, it's true. Maybe Donald Trump is just sort of the hypothetical we always used to give and what could go wrong in government. And now it's a reality, so we'll find out. We'll find out how resilient we are and whether it's just going to be fine. But a lot of the signs are not good.
So other hands up, Ron, and then in the back.
Ron Cass, a senior fellow at the Center for the Study of the Administrative State. One of the questions that Paul raised is the what would Nino say question. And Nino had an abiding confidence in the Constitution and the structure set up by the Constitution, and also an abiding distaste for starting by saying, here's the problem we have to find a solution to. Now let's find a solution. So one of his former colleagues on the DC Circuit used to say he wished that Congress would take care of problems, but if they didn't, he'd have to. I think Nino was exactly the other side of that. And Dick, I think in your paper, a lot of what you're doing is stuff Nino would say, yes, that's right, that sort of trust the procedures we have, trust the system we have. But I wanted to ask, do you think in part you lop over into saying in some pieces, I want the courts to step up here a little bit more. I want the courts to do a little bit more, because one of the things that Nino liked about Chevron, when Chevron was defined the way he defined it, was the division between the court saying what the law is and the agencies acting with discretion insofar as the law gave them discretion. Do you think what you're asking is for courts to be a little bit more aggressive in cutting back discretion where you think it does bad things?
I think to some extent I am doing that. And again, it's largely independent of the Trump phenomenon. Michael Livermore, very fine young administrative law scholar at UVA, just posted a piece on the Social Science Research Network talking about how courts can and should respond to this extreme political polarity phenomenon where the legislature doesn't do anything. They don't have the capacity to legislate. So what we get is we get a far left, a far right, and a far left and a far right. And so what do you do? Well, he has a bunch of doctrinal answers to that, and they mostly come under the category of having the courts step up and do a little more than they have been doing, particularly in terms of giving reasons when there's a change in policy. That's one of his big points of emphasis. And so I think, yes, but I also worry about them going too far and taking away powers that presidents need.
We have a question in the back, and then the next one will be right here in the middle.
Hi, Matt Lawrence from Penn State Dickinson Law. Question about federalism and how the states are doing, and elaborate on that. Open-ended, which is just where are the states in all of this compared to 10 years ago or 2 years ago, and the role of federalism. And then in particular, I was thinking about people from the federal government leaving, and I can think of several friends who've left the federal government and actually gone to states, and kind of like a ghost stateward young man kind of mentality. I'm wondering if you're seeing, across the board, that happening in states or others being the beneficiary of some of the morale issues in the federal government.
Michael, you wrote the book on federalism. Do you want to take that?
Grief. Well, I've updated pieces of that for the recent environment. One of the things that I think has been underestimated, at least in the legal scholarship, is that the fact that sort of the polarization that you see at the federal level is also now common among blocks of states, right? They litigate together, they, have their own plans, and there's a red state block and there's a blue state block. And you see that in many, many areas. I've written a little bit about why one might want to rethink some of the federalism doctrines in response to that reality, right? Because the way the Supreme Court has thought about it is always federalism is a matter of balance between the federal government and the states, and that makes sense in some contexts. They don't like to get sued, and they want to keep control of their criminal justice system and all the rest of it. So there are some areas of unanimity there. But when it comes to energy policy, environmental policy, and all the rest of it, that's a completely different matter. And so one of the things that I lament most about our current regime of constitutional doctrines is the complete paucity or emasculation, or whatever you want to call it, of horizontal federalism doctrines. There aren't any. And if you want to fix that, you'd have to rethink pretty big pieces of the architecture, and the court is just not willing or capable of doing that.
Could I add one point about the states? And you mentioned going to the states. There is a movement now to have at-will public employment in the states. 25 states or more, mostly states without public unions, have already gone to at-will public employment. There's a bill in Congress for us to consider at the federal level. It hasn't been pushed too hard yet, but at-will public employment is the opposite of public service and civil service. It gives enormous power to it's a kind of neo-spoils system, which gives enormous power to the executive, the governor, and whoever comes in and wants to clean house can do it. And I think that's a very troubling development. I hope it doesn't gain any more foothold at the federal level, but that's something to take note of.
I just make 2 points on state power. First thing, I see if there's excessive regulation, the states are principally responsible for it. I mean, my God, you cannot literally sell a bouquet of flowers without first going through the 200 hours required to get a license as a florist. In what, a dozen states now? State after state. They've got, it was bad enough when us lawyers had our little union and got the states to go along with our minimum fee schedules and like, it's unethical to charge too little for, well, now they're doing that with profession, and everything's a profession. You cannot sweep the floor of a barbershop without first going through hundreds of hours. So there's a terrible problem of excessive regulation at the state level. The Federal Trade Commission, to its credit, in both Republican and Democratic administrations, have been going after that pretty aggressively with some success. The other thing is, really picking up on Michael's point, they have mostly become litigators. Anytime Obama did something, every Republican state attorney general banded together and filed an action trying to get a national injunction, something Ron Cass is going to be addressing a bit later. And now every time Trump does anything, all the Democratic, so they mostly become excessive regulators at the state level and litigators at the federal level. I'm not crazy about what they're doing at the moment.
Bob, if I can put you on the spot on that. I mean, you spent years advising the president in the outset of his regulatory policy. What is it like to be in the White House overseeing these agencies, seeing those first policies coming out, and then having sort of a block of states all politically aligned, sort of leading a charge against the policies? I mean, what is the political I'm curious for your observation, since you saw it firsthand from the White House.
You're speaking specifically about resistance from the state taking that particular form?
Yeah, I mean, as Mike said, we do have sort of as a major feature of our federal administrative process now that the administration makes a policy, and then a coalition of states, we're going to have a former state solicitor general speaking this afternoon on one of the panels, sort of leading a block of states, almost always uniformly politically aligned, leading the charge against an administration's actions. What's that like?
Not terribly comfortable. What you find, and I hope I'm answering the question, but I think this is what you're describing as something that's sort of symptomatic of a larger experience you have, and I'm sure there were Republicans in prior administrations who would say the same thing. You begin literally on day one with an opposition that will say, we're going to stop by any means whatsoever we can what you plan to do that you campaigned on. Just starts from day one. So there might be, 48 hours of somebody saying somewhere, well, and I remember this very distinctly when members of Congress would come up, particularly on judicial nominations, and open a conversation by saying, well, we understand that elections have consequences. That was a favorite phrase. We understand elections have consequences. I knew as soon as I heard that phrase that I was in trouble, that the next word out of their mouth was, but I can't go with you on this in any way whatsoever. So one of the things we all know, and everybody will tell their story from each administration about it, it starts with questioning the legitimacy of an election. It goes on to arguments about whether or not certain policies have been constitutionally implemented. Naturally, what feeds into this is the very fractured media environment we have in which everybody's entitled to their own facts. And so the business of actually generating coherent, consistent policy and attempting to move it on a bipartisan basis is extraordinarily difficult. And one aspect of it is what you described. You have federal level opposition that's unrelenting from the beginning, and then you have, as you suggest, opposition out of the states on that kind of coordinated, litigated basis. So, the answer is, and by the way, the net effect of all of this is to drive presidencies even more into trying to find ways to exercise authority to solve problems when there's absolutely no other avenue they can find to solving them. And that feeds into the problem that all of us, I think, agree is a problem with the institution of the presidency at the present time.
Okay. Just one last question here in the middle of the room. The microphone's coming this way.
I am wondering, you had mentioned before, what would Nino do? But I was wondering when I was hearing the panel talking, what would Joe Cannon do? What would Sam Rayburn do when faced with situations like this? I think there hasn't been much discussion about, there's been a lot of discussion about the role of Congress, but there hasn't been much discussion about how Congress's role should change. I mean, I can remember back to times when congressional committees consisted of less than 10 people, and they actually did something, and they weren't just kind of a talk fest of 23, 24, 25 congressmen. I can remember times when bills were sent to committee and they were studied extensively for months on end, and then extensive reports were written. I cannot even think of a single bill in recent memory that has ever been treated to that much study. So the question really in my mind is, to the extent that Congress has completely abdicated its role in pushing back the president or pushing back the courts, what do you think should be done by Congress in order to change its ways?
Go ahead, Bob.
That's an excellent question. As you know, there's a whole school of thought that we need to do certain things to give the party leadership in Congress the ability to marshal majorities more effectively and, if you will, corral the cats. So there's been a significant amount of lamentation about the loss of tools like earmarks that are essentially, little goodies that can be distributed to bring recalcitrant lawmakers into the fold. And similar, there have been proposals, and by the way, that Cannon and Rayburn certainly would have favored, or Lyndon Johnson, to have the parties empowered more in the financing of campaigns so that they can use their authority in what are now, frankly, campaigns that candidates can run and finance largely on their own, to give the parties a larger role so that, once again, they can create more party discipline. My own view is that I don't know that any of that would work. I think there are too many powerful trends the other way. I heard Professor Pierce talk about the primary system. I think that that is illustrative of a larger problem, or let's not call it a problem, because it is a problem, but it is a development in the way that candidates run and are selected for office, and a measure of the extraordinary weakness of the political party system institutionally. I'm not talking about party identification as it's expressed in polarization. I'm talking about the institutional parties and how well they function, how well they're funded, how much control they have, what kind of a mass membership base they control. To the extent that that's gone for political cultural reasons, then the attempt to give parties leadership sledgehammers like that, I don't think would be particularly availing. And as a matter of fact, as you well know, and as we've seen, there are party leaders, there are members of political parties, including incoming freshmen and freshwomen, who actually make their name and begin to build, in some cases, toward presidential candidates by spitting in the party leadership's eye. And you know, if Cannon and Rayburn were around, and some of this behavior took place, the freshman in question wouldn't have a parking space, staff, or access to their household pets.
Well, I'm sure others have answers, but we are past our time. So I think we're going to bring this discussion to a close. Please join me in thanking all of our speakers.